38, those are the self-defense instructions associated with assault in the 4th degree with the alleged victim being Isaiah Williams.
I'm sorry, could you please speak up a little bit?
I said, if it's WIPIC 16.04 directly, I do not object if there's no changes to it.
All right, I would indicate I didn't compare the language. It said WIPIC 16 over. If you want to go ahead and just compare it really quick to make sure that it. I shouldn't say I didn't compare it, I did, but I want to ensure that I didn't miss something.
Just to be clear, the state did not modify it from the 1604 as it's provided in the WIPIC, Your Honor. Obviously, the only changes would be the selection or non-selection of any bracketed language. We didn't modify anything else that I can see or recall.
No objection, Your Honor, thank you.
All right, that will be included. Next, I am going to the section of instructions associated with the burglary in the 2nd degree charge. There was exception taken to the instruction currently number 41. The term enter includes the entrance of the person or the insertion of any part of the person's body or any instrument or weapon held in the person's hand and used or intended to threaten or intimidate another person or to detach or remove property. Mr. Leary took exception or objected to that instruction. I'm not going to give instruction 41. It does not apply to this case. Also, the WIPIC notes indicate that the instruction, this instruction would not be used in the usual case, as it does not define entry of the person in the usual sense, and the evidence that's been presented as it relates to the entry is that Mrs. Ali entered through the door. She did not break in any fashion, and her entire person went inside, as well as her entire person being just on, well, that's in the building at the high school. So I'm not giving 41. There was exception taken to by Mr. Leary as to number 43, which is WIPIC 6005, which is the inference instruction. And I would indicate that I reviewed the Brunson case, which is the primary case that was referenced in the comments and notes on use from the WIPIC. And it indicates that there are 3 important limitations that the court should consider as it relates to the use of this inference instruction. As it relates to number 2 and 3, I don't find that there's anything in here that would be an unconstitutional shifting of the burden of persuasion, and certainly this is not attempted, so it doesn't apply to those things. So I think really the first factor is what requires the analysis, and it indicates when the intent of the crime more likely than not flows from proof of the illegal entry, the instruction is appropriately given, provided the inference would not be the sole proof of the intent element. In the Brunson case, it's actually a consolidated case with multiple defendants accused of burglary, different types of burglary, actually. And in those cases, the defendants, there was evidence that the defendants had actually like broken into a building, broken a window, 3-foot hole in a door, that type of situation, and that was circumstantial evidence related to their entry with intent to commit a crime. And the inference was appropriate, and Mr. Leary has argued that this case is different, and therefore that the inference should not apply or should not be given, so as to not confuse the jury, and I think, and potentially to shift any sort of burden of persuasion. Although this case is certainly different, it is still appropriate to give this instruction because there is circumstantial evidence as it relates to her entry in the building, how she entered the building, when she entered the building, the notice that she was not allowed to be there based upon the letter or order from the high school and the like. And therefore, I find that it is appropriate to give the instruction related to inference in WIPIC 60.05, and I will include that. We left off looking at instructions 47 and 48. Ms. Zoe, on behalf of the state, had handed forward some new instructions shortly before our lunch break, which changed or added, I think it's really added to the language as it relates to count 5 for Mrs. Ali. Mr. Leary, did you have an opportunity to review those new proposed instructions, which are to replace what currently are identified as 47 and 48?
I did have an opportunity to review.
And do you have any issues with, let's start with 47.
I do not have an exception to 47.
All right. So I will give the new version of 47 on 48. I would indicate that the proposed language now includes applicable to the defendant in number 1, which had been an issue that you had previously raised. Do you have any other issues?
There we are.
All right, so I will give the 48. On the concluding instruction, which is really where we left off, 49 as well, I have, let me back up a moment. Mr. Kading sent me proposed verdict form and special verdict form based upon the assault in the 4th degree as a lesser crime from assault in the 1st degree. And he properly identified them as verdict form BBB and BBB-1. So I added those to the packet, and I added that information under instruction 49. I also then changed or added to instruction 49 an additional paragraph related to the second lesser crime. Currently, the version of 49 references the lesser crime of assault in the second degree. I just copy and pasted that paragraph and changed the verdict form lettering and changed the charge to assault in the fourth degree. And also indicated that that would only be completed if they found Mr. Ali not guilty of the lesser crime of assault in the second degree, or if after full consideration, they could not agree. That then they would consider assault in the fourth degree. So, and then I had added a paragraph for both Mr. Ali and Mrs. Ali as it related to the special verdict forms. That language had not, anyways, those paragraphs follow the paragraphs related to the instructions if there is a lesser charge. I'm going to start by hearing from you, Ms. Stone.
Ms. Joner, I think I tracked what the court was saying on what I'll call modified 151, with 151, which is that instruction number, I lost the number 49. That all makes sense to me. Plainly, I think I need to see it
Yes.
in print, but what the court outlined makes sense. In terms of organization, I think I'm understanding it consistent with the court's description, and if it is consistent, then I have no issues with that.
And also, I'm going to hear from Mr. Kading and Mr. Leary. It is still a clunky instruction now, but there just is a lot to instruct the jury on as it relates to how they approach the verdict forms. I believe, and of course you all will get the actual language later today, but I believe that it's consistent with the WIPIC language.
And I do think that instead of trying, as the court has done here, instead of trying to combine it essentially and consolidate some of that language, I do think it makes sense to simply repeat the language for
Yes.
each of those, so that if they start to feel lost, they can just go back to, okay, what do I do now if it's an assault court, and they can just restart that process essentially on its own. So I think that makes sense, even though it makes it lengthy.
All right. Mr. Kading, recognizing that you're not seeing it completely yet, any issue with the way that I described that?
No, Your Honor, it sounded, I too tried to follow, and it sounded very, very much as good as it can be.
Mr. Leary?
No further comment.
Okay. So I'd like to go through the verdict forms to ensure if anyone has any issues related to the verdict forms. Verdict form A as to well, first I'm only going to go through Mr. Ali's verdict forms, so I won't repeat his name with every verdict form. Verdict form A, Ms. Stone, any issue?
I did not see any, no, Your Honor.
Mr. Kading?
No, Your Honor.
Special verdict form A1, Ms. Stone?
Just fixing the name.
Oh, and I'm sorry, I have fixed the name on all of the special verdict forms. I did that over lunch as well.
Thank you, Your Honor. No other issues.
Mr. Kading? Verdict form B, Ms. Stone?
No issue, Your Honor.
Mr. Kading?
No issues, Your Honor.
B1?
Not that the court hasn't already noted.
And that means that I changed the name.
Yes, Your Honor, exactly.
Mr. Kading?
No issues, Your Honor.
All right, so then on BB, Mr. Kading, you had proposed an instruction for BB, which is the lesser crime of assault in the second degree. And it was not quite the WIPIC language, so I did use the WIPIC language in a proposed verdict form BB. You can see how they're differentiated. I have one proposed by Mr. Ali, and then I put one with the WIPIC language. Do you have any objection to the use of the verdict form that's currently identified as BB-WIPIC 180.05?
No, Your Honor, we should use the correct one, which is yours.
All right. And Ms. Stone?
Correct, that's same, Your Honor. Thank you.
All right. And then we have BB-1, Ms. Stone.
No, Your Honor.
And I have changed the name for Fatima in that one. All right. And I'm sorry, Mr. Katie, any issue with BB-1?
No, Your Honor, thank you.
All right, so I used Mr. Kading's proposed verdict form BBB that he sent over the lunch hour. Did you have any issue with that, Ms. Stone? And that is for the consideration of the lesser crime of assault in the 4th degree.
No, Your Honor, as long as it conforms to the WIPIC as the court has previously identified it for BBB. I believe it does.
I believe that it does as well. All right, and as to BBB-1, any issue, Ms. Stone?
No, Your Honor, and it does have that change made to Ms. Ali's name.
All right, Mr. Kading?
I think it's right, Your Honor.
All right. Then we have verdict form C. Any issue with that, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
C1, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
And then verdict form B, Ms. Stone?
No, Your Honor.
And Mr. Kading?
No, Your Honor.
All right. Now I'm going to switch to the verdict forms for Mrs. Ali, starting with verdict form A. Ms. Stone?
No, Your Honor.
Mr. Leary?
No issue.
Verdict, special verdict form A1?
No, Your Honor.
Just one moment.
I'm not noting, just to be clear, her name in each of these. I understand the court's changed that.
Yes, I have. Mr. Leary on A1.
If no objection, I will just acknowledge now that the court.
I'm sorry, could you?
I'm sorry. No objection, and I will just note that the court has acknowledged changing Fatima Ali's name to the full name in all the special verdicts, and I will not respond again as to that issue.
All right, thank you. Verdict form B, Ms. Stone.
No, Your Honor, no issue.
Mr. Leary,
No issue.
B1.
No issue, Your Honor.
Mr. Leary.
No issue.
C.
No issue from the state, Your Honor.
Mr.
No
Leary.
issue.
C1.
No issues from the state, Your Honor.
Mr. Leary.
No issue.
And then D, Ms. Stone.
No issue from the state, Your Honor.
Mr. Leary.
No issue.
And then E, Ms. Stone.
No issue from the state, Your Honor.
Mr. Leary.
No issue.
All right. So I do think that there's one last issue that we need to address. I do not assert myself in jury instructions or in legal issues. I think that's the lawyer's job, and this may be a non-issue, but it's also my job to instruct the jury correctly at the conclusion of a case. And on the unlawful imprisonment charges as to both Mr. Ali and Ms. Ali, they are charged, and then it says that there is a notice of domestic violence, but there are no facts alleged in the information as it relates to the issue of domestic violence. In the other charges where domestic violence is alleged, it has language to the effect, it is further alleged that the defendant, and it has either Mr. Ali or Mrs. Ali, commit the above crime against FIA, a family or household member, as defined by the statutes. The unlawful imprisonment counts in both informations do not have that language in it. And so I don't know if that is an issue as it relates to the special verdict form for that count. And if it's not, then everything stays the same. I can take a recess if the parties want to look at that issue.
We have a moment in time.
Yes.
Thanks.
I'll go ahead and take a 10-minute recess so the parties can look at that and think about that. Thank you.
All rise, court's in recess.
All right. Ms. Stone?
Yes, Your Honor, I have provided copies of a third amended for Mr. Ali and a sixth amended for Mrs. Ali, information that just alleges or provides that information on the unlawful imprisonment consistent with the notice of domestic violence, notice of domestic violence for count 3, which is consistent with all of the language up top, both on counts 1 and count 2, including the family or household member with the dates associated with that. I provided copies to defense counsel. I provided bench copies and a notice to file or copies to file with the court as well.
All right, thank you. Mr. Keating, as to arraignment on the third amended information?
Your Honor, if I could just have one more second.
Yes.
Your Honor, I'm going to object to the amendment for the following reason. The state, having previously rested, I believe that the DV designation in this case constitute an enhancement, not only as a element that they are asking to be proved in this court, but for future charges. It does have a lasting effect in terms of scoring offenses, and for that reason, I think that it's more than just a formality that this be amended at this point. Mr. Leary has additional information.
Mr. Leary?
I would note an objection. State versus Pelky, 109, Washington 2nd, 484 at 490, identifies a bright line rule. As a criminal charge may not be amended after the state has stated its case in chief unless the amendment is to a lesser degree of the same charge or a lesser included offense. Anything else violates the defendant's Article 1, Section 22 right to demand the nature and cause of the accusation against him or her. Such a violation necessarily prejudices a substantial constitutional right within the meaning of Criminal Rule 2.1e, which is now Criminal Rule 2.1. Subsequent case law lessened that rule, where there was a situation where an amendment to the crime charge and its essential elements remained the same, but the date of the violation was expanded, and found that the changing of the date did not necessarily implicate the Pelky Rule, and thus the defendant did need to establish prejudice. So here, we have a situation where the state is adding an additional element as to count 3, in my case, which is the domestic violence allegation, as they indicate in the proposed amended information that they are further alleging that my client did commit the crime against FIA, a family or household member as defined. So, under the Pelky Rule, it is not an amendment to a lesser included offense. And this is after the state has rested. We just also note that this is the end of the third week of trial, and the state has had ample opportunity to review the information. The court has identified repeated errors and mistakes in the allegations contained in the information, to the extent that we're currently operating under the 5th amended information, and the state is now seeking to go to the 6th amended information. Once the state has rested, both defendants have rested, and we've essentially completed the jury instructions and ready to proceed to trial, or to closing.
Anything further?
No, Your Honor.
Ms. Stone?
Thank you, Your Honor. So as the court looks at the third amended for Mr. Ali, count 3, and the court looks up to both counts 1 and 2, which have been consistent. I would also point out at count 3 clearly identifies unlawful imprisonment, notice of domestic violence allegation dash FHM, family household member, after 7/1/2022, all of the associated RCWs. That notice has been consistent throughout, regardless of what information we have been on. That same is true for Ms. Zara Ali in terms of that language, so it is not a surprise. Counsel has been on notice of that. There is no prejudice to the presentation of their case. So it's not an amendment, as in something is being added, it was already in there. There's clarifying language following underneath of that count. It is not a additional change to what was previously charged already in that information. Notably, in terms of the counts 1 and 2 for both defendants, that language has already been in there with those same references, cross-referenced essentially in the same documents. So that notice has been there. There's no change in terms of adding family household member to the arguments or presentation of the case as counsel has inquired. When we talk about the Pelky Rule, the concern with the Pelky Rule is that the state then amends an information such that counsel would not have had an opportunity to properly ask questions, cross-examine witnesses, or address that evidentiary issue prior to the close of the state's case. That is not the case here. So I would disagree in terms of the Pelky Rule that it does not apply here. That is different. And when then that turns into counsel having to provide prejudice for surprise or some way to not prepare appropriately for their case, and that is not the case since it is already charged with the explanatory language 1 and 2 and has remained so throughout. It is in fact charged in count 3 for the unlawful imprisonment for both of them, as it has been throughout. The explanatory language and the narrative fell off in a scrivener's error. So that is the state's position.
Ms. Stone, does the defense have to prove that they are pressed if I were to allow the amendment at this point in the trial?
I believe
I don't know, and that's why I'm asking.
I believe that they would if it was either vague in terms of not knowing what was presented, or if it was not on notice at all. If it was either a surprise or it was vague and they were not able to be able to present that. Under Pelky is if you were adding a charge altogether, such then that counsel couldn't have asked the questions that they wanted to ask on cross-examination. They couldn't have properly prepared to defend their case, etc. That is not what we have here. If I would say that the situation would be very different if it was only in the header and there was no other charge for which that information was relayed, or charged, so to speak. If that narrative language wasn't included anywhere else in that document, we have consistently had the same domestic violence charge tag added in each of counts 1, 2, and 3. We've discussed it as such. We've actually gone through the jury instructions and everyone agreed that that special verdict forms applied to each of those counts because everybody was operating in the same belief that that language was there. And so there is no surprise, there's no change to how counsel would have asked their question. It applies equally to counts 1 and 2. And it is listed in count 3 itself. The explanatory language underneath was not also provided in a scrivener's error. So I would ask the court to decline the request.
Mr. O'Leary.
I would direct the court and the party's attention to State versus Brooks, 195 Washington 2nd, 91 from 2020. Head note 7, 8, and 9. So basically, if the Pelky Rule applies, and to talk about it being a bright line rule, prejudice is not required. Head note 9 talks about where the Pelky Rule does not apply. The defendant has the burden of demonstrating prejudice under criminal rule 2.1D. And so I would just, so this is at 195 Washington 2nd, at the bottom of 97 through page 98.
Can you address Ms. Stone's argument that this is not consistent with the Pelky rule and the bright line rule?
Yeah, so the Pelky Rule states, criminal charge may not be amended after the state arrested in its case in chief unless the amendment is to a lesser degree of the same charge or a lesser included offense. So adding the domestic violence allegation designator, it is not a lesser degree of the same offense or a lesser included offense. Anything else is a violation of the defendant's Article 1, Section 22 right, okay? So, and the only exception that I'm aware to the Pelky Rule is something that expands the date or modifies the date. So the amendment sought by the state is not a lesser degree, is not a lesser included offense, and does not correct the date of the charged allegation. So the addition of the DV designator is not permitted by the Pelky Rule. And so we don't even reach the issue of prejudice.
I think that the parties disagree because it isn't an amendment. The state has not changed the charge. The charge unlawful imprisonment with domestic violence, family household member has been charged throughout. The state did not change the charge. It did not up the charge. It did not add an enhancement to the charge. It is the same charge with clarifying language in the narrative, and that same charge is referenced, or that same enhancement, or not enhancement, that same designator is referenced throughout the document otherwise. So counsel has had notice to it. The Pelky Rule does not apply because it specifically is not amending or changing the charge that has been there since the beginning of this case.
All right, can you, Mr. Leary, give me the cites to the cases that you referenced? I got State v. Brooks, 195 Washington 2nd, 91, which is 2020. And the first case, which was 109 Washington 2nd.
So that's Pelky,
That's Pelky. And what's the year of that case?
1987. So 109 Washington 2nd, 484.
Yes. All right. And Ms. Stone, I recognize the argument that it's distinguishable. In addition to that, is there any case law that you want to cite that I should review? Although I identified that this was a potential issue, I didn't research it.
I have not had time to do that, Your Honor. I was trying to fix the information, so I have not had an opportunity to look at anything other than literally the court came back in after I came in with the information.
Okay, so would you like an opportunity
Yes,
to look at
please.
that? All right, so I'm gonna take a, I'll take a approximately 10-minute recess. I'm gonna look at these cases. As you may identify cases that you believe are important for my consideration, if you're able to either provide a copy of the case or the site to my clerk and of course opposing counsel, I will look at those as well. Thank you.
All rise, court's in recess.
Ms. Stone, did you have any additional authority?
I didn't find anything on point.
All right. Let me ask you this. The charge is unlawful imprisonment in count 3. What is the notice of the domestic violence allegation?
The notice of the domestic, the notice of the domestic violence allegation is, I would argue in the header itself, but in terms of the provision is associated with that, it is also repeated throughout 1 and 2 with that same language specific to family or household member.
And I don't think my question was, I apologize, was very clear. So the cases, well, there are 2 cases, but they talk about the fact that the state should not be allowed to amend after they rest if it is to add really what's going to be an essential element of the crime charged. And so the crime charged is unlawful unlawful imprisonment. And that's why I'm asking, what is notice of domestic violence? Is that a crime charged? Is that an enhancement? What is that, and how is that different? Because it's clear that the essential elements describing what that is are not in the information.
Correct, Your Honor. The charge itself obviously is unlawful imprisonment. Every essential element of unlawful imprisonment is noted
Yes.
within count 3. I think the reason it's called, it's not an enhancement. It is not a separate charge. You can't just obviously charge notice of domestic violence without it being attached to a particular type of charge. So I would argue that it is a category of a crime. It's notifying that this is a particular type of crime. It is not an enhancement, though otherwise. There is no, for example, if the court goes into, and I may misquote my RCW, I believe it's 994A 533 or 535, if I'm remembering my RCWs correctly, that has the list of enhancements. Those are obviously not, domestic violence is not any one of those as a separate allegation. That's why it's listed, it gets listed as notice of an allegation, because it is a classification of a type of crime versus an enhancement. There's no mandatory sentence that is added to it. There is no change to that. There's not an essential element of the crime charged itself, and that's why the state's position in this case is that the crime charged is the same. The elements, the essential elements of that crime of unlawful imprisonment have been presented throughout this period of time. The DV, domestic violence designation of that crime in and of itself is not the crime itself, and there's no essential element to the crime itself that has been charged as it relates to count 3. So I don't believe it counts as an enhancement. It's not listed as one of those enhancements in the RCW. It is listed as a separate designator. So for that reason, I don't think Pelky applies for that purpose. And because Pelky doesn't apply, then I think counsel has to demonstrate that has been unfair prejudice or really any prejudice to them in the presentation of their case or their ability to prepare, because I believe this falls more in the context of say Brooks, where there's a change to the date or something like that. Even in that case, I would argue to the court that that is an essential element of that crime. The date has to be something that you prove and you're preparing for, and in Brooks it didn't count as that. So here, because the DV designator is not an essential element, it is an allegation, not an enhancement, not a freestanding charge, not a separate charge to that. Pelky doesn't apply to that designation addition, and because Pelky doesn't apply, then counsel has to demonstrate prejudice, and there is no prejudice to demonstrate here because it's already charged in counts 1 and 2, just as it was charged in count 3, but it has that additional language identifying what that notice is in counts 1 and 2. And all of the questions that we have asked, and specifically defense counsel has asked throughout this case, whether the defendants are the parents of the alleged victim in this case. And so that doesn't change. I don't think they can demonstrate that prejudice. I think that would be the appropriate standard without having been able to find anything about a allegation specifically or an enhancement. Any enhancements were referencing like a school zone enhancement or a deadly weapon enhancement or a firearm enhancement, which automatically comes with an additional 3 years or an additional 5 years or an additional 24 months based on the nature of that enhancement. There is no additional time that automatically adds when you add that DV designator to this crime. So I think that prejudice hasn't been provided. I think it would have to be demonstrated, and I don't think it can be demonstrated here.
All right, thank you. Mr. Larry, anything further?
To some extent, it's a distinction without a difference. I mean, to say that this isn't an enhancement doesn't require, school zone enhancement or, additional mandatory penalties. I mean, the DV correct me if I'm wrong, I don't have the SRA manual in front of me, but is the state saying that if my client is convicted of domestic violence, attempted murder in the second degree, that the unlawful imprisonment count isn't going to add a point to her score? Because that has a direct correlation as to her sentence. It enhances her sentence by a point, which can be quite substantial depending on, if this was a standalone charge. Well, even then, in the future, as Mr. Kading said, there is an additional consequence. There's a reason why the state is attempting to further allege, and that's because of the sentencing consequences are, and therefore, under Pelky, it's clear it's not an amendment to a lesser degree or a lesser included offense. It doesn't modify the date. There's no authority to suggest that they have the ability to amend post resting. The afternoon before we head into closing argument. Nothing additional.
Your Honor,
Mr. Kading?
Just to clarify, Your Honor, regarding the future, as Mr. Leary mentioned, one of the changes that's been made recently is that if you have two domestic violence related events on separate days, neither one of them can ever be removed from your record. So if someone has a prior domestic violence on their record and then they go to trial and they're convicted of the second, both of those are they can't be removed from the record. You can't do a vacate because you have two different days. So there are potential consequences that are long lasting from a DV allegation that are not necessarily manifest in this particular case in terms of an enhanced penalty now, but it certainly can affect you down the road. It certainly does have consequences. If it had no consequences, there would be no reason to make a further allegation of domestic violence. It would be a moot point and we wouldn't do it. But we do it, we keep track of those things, and it does have consequences beyond this case.
All right, thank you. So, first of all, I indicated that, and I don't ever try and insert myself into the trial or raise issues for parties. I recognized this issue when I was preparing at the start of the trial. I recognized this issue when I was preparing before we ever came into court about how I was going to read the information to the jury. And I specifically went over with the parties how I was going to read the information to the jury. And I said it in such a way that I thought it might raise the issue to the parties, because when I talked about count 1 and count 2, I specifically indicated that I was not going to read the last sentence. And then when I got to count 3, I said I was going to read it as is. And I recognize that the parties are focused on so many things. I also didn't raise it until we were all the way through the jury instructions, because I thought one of the lawyers might raise the issue, and I would not have raised it at all if I did not believe that it could have been a constitutional issue, because other issues, frankly, are waived or could be waived if not raised, but constitutional issues can be raised at any time, and the court wants to ensure that it is addressing issues that could be of a constitutional magnitude ultimately. But with that said, I didn't try and research the issue in advance, again, thinking that the parties might be addressing the issue with the court. This is a situation where the state is seeking to amend both informations, as the information to Mr. Ali and the information to Mrs. Ali as to count 3, seeking to add a sentence at the end of count 3, being identical except naming each defendant in each of their cases. It is further alleged that the defendant, Ihsan Ali or Zahra Ali, did commit the above crime against FIA, a family or household member, as defined by, and then it lists the statutes. As it relates to amending the information, the standard, according to the Brooks case, is abuse of discretion, and the court looks at whether or not, ultimately, and what I should be looking at is whether or not the decision is manifestly unreasonable or based upon untenable grounds, and whether or not it's, of course, most importantly, based on the correct standard. The state is required to allege in the charging document all essential elements of a crime to inform a defendant of the charges against him and to allow for preparation of defense. That's a constitutional right that each defendant has. In this case, the crime charged, under count 3 is unlawful imprisonment. There is not a separate crime of unlawful imprisonment domestic violence. That's not like a separate definition within the RCW. There is a notice of domestic violence that is included in the informations that have been at trial, that being a second amended information for Mr. Ali and a fifth amended information for Mrs. Ali. The rule allows for an information to be amended at any time before verdict or finding if substantial rights of the defendant are not prejudiced. I do not find that this is a situation where Pelky applies. This is not a case where the state is seeking to amend to a new charge. In the Pelky case, the state, after everyone had rested, moved to amend to a different crime, from bribery to trading in special influence. And that is not the situation here. And the Brooks case is a case involving sexual assault and misconduct against a youth, and in that case the amendment was amending the date range. So I don't find that this is the bright line rule indicated by Pelky, as I don't find the notice of domestic violence is an essential element of the crime of unlawful imprisonment. And I do not find that the defendants have proven that they have, or that there is evidence that their substantial rights have been prejudiced. And I indicate that because the defendants have been on notice with the specific facts as it relates to the issue of domestic violence from the other counts, including count 1 and count 2. And I know that those may have changed as degree or the type, but they have been alleged to be domestic violence charges, even as they may have been amended. And both of those, count 1 and count 2, has the language that it is further alleged that the defendant committed the crime against FIA, a family or household member. So they've been able to fully litigate the issue of domestic violence throughout the course of this trial, have been on notice with the information contained, or with the facts alleged in the information that have gone to trial. Again, second amended information for Mr. Ali and fifth amended information for Mrs. Ali. And therefore, although the evidence is closed and both sides have rested, I am going to allow the amended informations to proceed forward based upon the reasons I have already articulated. Mr. Kading, as to arraignment on the third amended information for Mr. Ali.
Your Honor, we will acknowledge receipt, waive further formal reading, enter pleas of not guilty.
A probable cause has previously been established. Pleas of not guilty shall be entered as to each of the 4 counts before the court for Mr. Ali. Mr. Leary, as to arraignment on the sixth amended information.
Preserving the objection, the defense would acknowledge receipt, waive further formal reading, ask the court to enter pleas of guilty to the 6 counts.
Probable cause has previously,
5 counts.
it's 5 counts. Probable cause has previously been established. A plea of not guilty shall be entered as to each of the 5 counts before the court as to Mrs. Ali. You have the originals of the new information? Okay. Having addressed that issue, then there would not be a change to the jury instructions as we have addressed to this point. Almost 3 o'clock. I believe that I should be able to finalize the jury instructions in approximately the next 30 minutes, and then I'm going to have my judicial assistant review them just to make sure that they appear correctly and are correctly numbered. And they will be emailed to you by 4:30 today. I ask that the parties review the instructions and that the parties confer if you see any error, because even after all that, there can be a mistake in the instructions. If you see an error, I ask that the parties confer between themselves so that we can address, you can address it in an email that everyone's on and everyone has at least been advised of whatever the issue is.
Your Honor, as it relates to Mrs. Ali's, the change that we previously made to the Sixth Amendment to fix it from North Thurston High School to Timberline reverted back to North Thurston High School on count 4. I wish I was making it up, quite frankly. I need to fix count 4 to reflect that it says Timberline High School as it previously was. While the court is doing that, doing the next 30 minutes, or the other option would plainly just to be to line it out. And that would be I would be fine with that. I don't think there's any confusion that we're talking about Timberline High School.
I think because I've already arraigned Mrs. Ali that it cannot simply be lined out. Why don't you have that, why don't you prepare your new information, but bring it in. I didn't intend to keep the parties here while I'm working on the instructions. I think the parties should be able to attempt to go back to your offices, and then the instructions can be emailed. But if you can do that, I definitely want to take up another amended information before Mr. Leary leaves.
Yes, Your Honor. Thank you. What? Yes.
So I will be in recess. My clerk will call me once that comes in.
All rise, court's in recess. Can you just send a message on to
present now only under 24-1-132534, State versus Zahra Ali. A 7 amended information has been handed forward. Ms. Stone, did you have an opportunity to review the information to ensure that it is complete?
I believe so, Your Honor. I did not find any other errors, nor did Ms. So. I will tell the court on count 4, we took out essentially that to-wit language. It now simply says, did enter or remain unlawfully in a building. And we've only talked about one building during the course of this, Timberline High School, so there should be no confusion as to which building is being referenced throughout.
We would acknowledge receipt. Larry, on behalf of my client, would acknowledge receipt of the 7th amended information. Waive further formal reading. Ask the court to enter pleas and regularity to counts 1 through 5.
Probable cause has previously been established, and a plea of not guilty shall be entered as to the 5 counts before the court. Court will be in recess. Thank you.
all rise, court's in recess.
May I have a question? Is it the court's intent that I stay here until I get that email, or can we work tonight if there is an issue?
And please be seated. I apologize if I was not clear. The email will go out. I expect that the parties will be communicating either by phone or email. If you see an issue, I would just like you to consult together before you contact my judicial assistant, so that hopefully any issues are, I get one email and that we can make those corrections. I want to print the instructions on Friday because it will take quite a while to run those instructions, the number of copies that we need.
Your Honor, I wanted that by noon tomorrow, is that correct?
That's correct, and that'll be included in the email that comes from my judicial assistant.
Yes, Your Honor,
Thank you.
Thank you.
All rise, court's in recess.